in the Court of Appeal, I had a matter in which we were debating as to what is the timeline for a person who wants to apply to the Supreme Court to the Court of Appeal for certification that is a matter of general public importance.
So what I guess the three. So what is the first issue?
So what changed is that now in the rules, now it's clearly provided that if you make an application, you make it within 30 days.
Okay.
Number two, the time that a judge is entitled to keep or to reserve the reasons for the judgment has been expanded from I think 120 days to 180 days. And I think there are also now the rules about service. You can serve by email, you can serve with the phone. I think those are the changes.
Yes. Just familiarize yourself with that part of the law. Secondly, how does this, in what respect to the Court of Appeal rule, you just give me two ways in which these 2022 rules materially differ from the election petition rules in terms of the process.
Sorry, Commissioner,
I'm just saying, yes. These 2020 rules,
yes.
Now I want us to deal now with the election petition rules.
Yes.
There is a material difference in terms of the process. Can you just tell us about it? Because it's very, very material.
Number one is the timelines. The election petition rules for the Court of Appeal, they have put very fixed timelines.
Let me put it this way.
Yes.
How is the jurisdiction of the Court of Appeal invoked?
By filing the notice of appeal.
Okay. So in what ways does that notice of appeal differ in the normal rules and in the election petition rules?
Now the notice of appeal has to contain more details. It has to indicate, especially the grounds, whether you are appealing against the whole or part of it. It requires much more detail, unlike in the ordinary matters, where it would be okay to indicate that you are appealing against the whole or part. But in this one, you have to give many more details. Very much like a memorandum of appeal.
Okay.
Very much. Yes.
Maybe you will familiarize yourself with where you file the notice of appeal.
Let me indicate because maybe I have not got the question. In the election petition, in the election petitions, you file the notice of appeal in the Court of Appeal, unlike the ordinary rules where you file in the High Court. I have not understood the question.
Okay.
Yes.
So why do you do that? Maybe the reason why that is done.
My understanding is that in the High Court, okay, in the ordinary matters, you are filing the notice of appeal in the High Court to give notice to the High Court and to other parties that you are appealing. In the Court of Appeal, because of the strict timelines for hearing the appeals, I think 6 months, then you are alerting the Court of Appeal that I have come. Let's start counting the time.
Okay, thank you very much. And finally, my last question.
Yes.
Can you illustrate to us the difference between discrimination under Article 47 of the Constitution and differentiation? Just give us an example.
Discrimination is differentiating without a lawful justification. Let me use the two words. Discrimination is differentiating without a lawful justification. Differentiating is discriminating with a lawful justification. For example, if I'm recruiting the KDF or night watchmen, I will recruit specifically men because they are the only ones who are fit for the purpose of being night watchmen. I've never seen a lady being employed as a night watchman. So that's differentiation.
Okay, thank you very much. You'll convince my colleagues. Thank you, Chair.
Dr. NDEGWA, I'll ask you 4 questions.
Yes.
Now, let me start with your article regarding bail and bond.
Yes.
And what I've noted from my reading of the article,
yes,
is you actually propose to go a step further by removing this requirement for, for depositing of titles and logbooks and all that for good reasons, and I appreciate that.
Yes.
Now, which brings me to the question: how do you balance that against the public rights, where the accused person may be a danger to the society? Is the rights, of course, of the accused person, because they are presumed innocent. I appreciate that.
Yes.
But there is also the right of the public to be protected.
Yes.
Now, I have a case in point, say, like accused persons who, of course, are still be innocent, like in Mawanga. You've heard about the latest scary situations of women being raped, assaulted, killed, and even their bodies burnt. Now, I'm asking myself, when you have, say, such persons will be arrested, who are still innocent, but now even the minimal conditions of that would ensure the appearance in court are removed in terms of this documentation, where does that leave the rights of now the public? I don't know whether you'll be able to explain further how you'll be able to ensure the two are balanced. Rights of the individual against the public safety.
Yes. Thank you, Commissioner. I believe that I have understood the question, but let me start by going just backwards a little bit further to say that the approach that I took when I gave that example is that of social justice, that when you have accused persons, one has a title deed and a logbook, the other one does not have. They have committed the same offense. In fact, they are co-accused. Just because one is doing well in society, the other one does not have resources. One will be in the remand, the other one will go free. Now, that said, so to that extent, that is an inequality, an exclusion, which we are trying to address. Now, separately now, when you go to the criminal procedure, you'll be shocked to find that there is nowhere it requires a title deed for a logbook. Through and through, the criminal procedure code talks of security in terms of a sum of money. So even if this person, okay, so the idea is this, that when we ask for a logbook or a title deed, it does not help in any way in getting the accused to come back, in any way. Even if you have 10 title deeds, it won't make the accused come back. So the obligation of the court in the Constitution is to impose conditions that will ensure that the accused person comes to court. Yes, and so these conditions can be anything. You can tell him, yes, you can do like they do in America, you put an electronic tag so you know where he is all the time. You can get the family to commit that this person will be coming to court. You can get the brother, you can get the sister, but you can even keep him in the cells. The important thing here is this, that whatever condition that is, okay, if a person is a threat to society, he shouldn't get board in the first place. If he's a threat, he shouldn't get board. But if he gets the board, the surety board for that matter, then we should not discriminate that the wealthy will enjoy surety board, the poor and the other majority won't. So I don't know whether
you now captured what I wanted to come to, because I got the impression that in your article it has given more attention to removing even the very minimal conditionalities, but it did seem to capture Article 49, which says unless where there are compelling reasons
Yes.
not to grant the bail and bond. So there was no, there seemed not to have been a due emphasis on the compelling reasons that would others, some of which would be the public safety. But now you've captured it.
Thank you. Thank you.
Yeah, so now I'm just wondering if now you are to get to the Court of Appeal,
Yes.
what jurisprudence would you develop to balance the two? And I'm not in any way suggesting that people should be kept in custody,
Yes.
but just to balance, because I'm looking at, say, a fellow has been seen in CCTV at M-Pesa points, shooting people, around.
Yes.
He is arrested, is brought before the courts. Then he's told, you can leave, and then attend court as and when the case comes up. It takes 10 years. In the meantime, he's killing more people.
Yes.
So what jurisprudence do you develop to balance the two, not just the issue of the rights of the accused, but also the public interest?
Yes. Thank you, Commissioner. Let me explain again the concept, the argument in this paper. The argument starts by separating those people who are a threat to society and the ones who are not a threat. The ones who are a threat are not entitled to be released on board. They are not entitled to be released on board. But once we determine that a person is not a flight risk, he is not a threat to society, and therefore he can be released on board, then what are the conditions? Yes. So my paper now is saying, if we choose that this is a person who is not a flight risk and is not a threat to society, let us not now discriminate. Let us not discriminate as to who will get, who will not get. That is, I hope.
Now let me move to the second paper.
Yes.
That you one of your sample writings, and just to follow up on what Justice Ibrahim raised the issue of these mini attorney generals.
Yes.
And again, I can understand where you're coming from.
Yes.
Because the issue of corruption and loss of public funds and all that,
yes,
it's a big concern to this country.
Yes.
But now I'm just wondering, again, picking from what the concern that he had about frivolous and vexatious proceedings.
Yes.
And the person now in the civil proceedings, you see, once a suit is filed, one has to defend themselves.
Yes.
So I'm just imagining where there are all these frivolous and vexatious proceedings.
Yes.
Now, to forestall that,
yes,
would it not have been a better mechanism to come up with a mechanism of compelling the relevant institutions, not the private individuals going to court themselves, because now you have assets recovery agencies who are doing a good job from what we are seeing so far. The EACC were also doing a good job in terms of recovery of these assets.
Yes.
Of course, the Attorney General still has the responsibility.
Yes.
So why not come up with a mechanism that compels those institutions as opposed to the individuals? Of course, I've appreciated what you said about giving a notice and all that. But if those institutions don't take action, why not compel them through the legal processes so that the onus on them as opposed to having these so many mini attorney generals?
Okay. Let me start by explaining that the design of the draft bill had put in a mechanism for preventing abuse. One of the provisions was this, that before the defendant is required to answer, the person, the claimant, obtains leave of court, so that there will be a nice way of saving the frivolous from what has substance. So leave, you obtain leave, so that a defendant will sit and wait for the court to determine if there is merit or it's no merit. That was the mechanism that I put in place. And I would also look at it this way, that the bill was giving an opportunity, first and foremost, to the Attorney General, including permitting that the Attorney General can take over anytime. You file in his name and he can take over anytime. So we were not giving any chance for the claimant to do something independent from the office of the Attorney General. Yes.
Yeah, I appreciate that. I was just saying that so once somebody has a suit filed against them,
Yes.
they still have to defend themselves.
Yes.
That means legal costs.
Yes.
But would it be more timely if the proceedings by the private citizens against the institution that is supposed to take action, compelling them, as opposed to going directly against the other private citizen? That's where I was saying, I was just wondering. I'm not saying your line is wrong.
Yes.
I'm just asking which one would be better and more timely between the two, in your view.
In my view, it is better for this person because he's doing it in the name of the public, not in his name, in the name of the public. It's better for him to work together with the Attorney General than to start fighting the Attorney General. That was the concept. Yes.
Okay, my final two questions.
Yes.
Now, you'll appreciate that one of the major challenges lawyers have with the courts generally now, and let's now address the Court of Appeal, is the delays in conclusion of matters.
Yes.
You've seen even in observed groups, some of which I am with you, where lawyers keep complaining that matters are taking too long in the Court of Appeal. Yes, they can't be expedited. Now, I'm wondering if you are to get to this Court of Appeal, what are the techniques that you'd apply in ensuring that matters are concluded expeditiously? We accept the challenges that the courts have, but still, there has to be something that can be done to ensure that matters are concluded expeditiously.
Thank you, Commissioner. I think the very first one would be very intensive and very proactive case management. Very proactive would be the word, proactive and intensive. Because I have seen many cases where the deputy registrar gives directions, file your submissions by this date, but then they don't file, and then nothing really, the consequence does not really visit. Yes. So my view would be that if we say file your submissions within the 7 days, then those 7 days you file. If you don't file, then there should be some consequence. That's number one. Number two, I think I would want a situation whereby if a matter can be sorted outside, maybe by mediation, by conciliation, it should be possible. It should be possible to refer parties to those alternative methods of resolving a dispute. But for the matters that remain in court, I would suggest intensive and proactive. Proactive in which sense? That maybe as soon as an appeal comes, maybe the judge should be able to, if it's allocated to a judge, to take the file and decide this is the issue, this is a core issue. I want it addressed this way, and in so many days, maybe by written submissions. So that instead of waiting for the lawyer to come and say so many things, yes, you should take the lead. The judge should take the lead and guide them. Yes, proactive. Yes.
But you see, now in most of these cases,
yes,
the problem is not on the part of the advocate. They find their submissions, they've done their thing, then even getting a judgment, or even getting the actual hearing, forget even about the judgment, getting to a stage of being heard is problematic. But of course, there can be alternative dispute resolution because the matter is at the appeal level. People have filed appeal, which means they disagree all the way, so they want a determination. So I'm just wondering, in terms of managing that, the courts, what are these steps that you take to ensure that you're not there together, of course, with the others that are going to appoint, and then still, we are back to zero, where matters are not being heard and their judgments are not forthcoming. I'm just wondering what techniques could be applied on that.
Let me start by saying one of the observations is that number one, we don't even have enough judges. That's number one. So the very first thing is that we need enough judges. Then number two, I would imagine that we need to bring more accountability. I'm not saying that there's no accountability, but we also need it. Things like maybe performance, measuring performance, so that there is more output. And also discussing with colleagues and agreeing that we need to expedite justice. Those are some of the techniques that I would see.
Okay. Now, my final question, Dr. NDEGWA. Of course, you're a good lawyer, there's no doubt about that.
Thank you for
One
that
thing, when it
compliments.
comes to the issues of the learning curve, some may pose a question and say that probably because of, you move directly now to the Court of Appeal. I don't know whether you've had opportunities of conducting actual hearings, maybe arbitrations or having a situation where you're sitting in a collegiate, where you're sitting together with other colleagues and determining a matter, not as a judge, but again, even whether it's in arbitrations or whatever it is, to reduce the learning curve in terms of the moment the moment you move to those courts, you are ready to get going. I don't know that you can be able to give us some kind of a...
Yes, I've had some advantage of sitting in quasi-judicial domestic tribunals. In the Anglican Church, we have what we call the Bishop's Court. It tries the errant laity and clergy. That's because all kinds of issues come. And as a chancellor, I am a member. Yes, so I have an experience of how to determine issues. Number two, at the university, we have all these issues with discipline, and they are the disciplinary boards. Yes, at all levels, and I have sat in them. So I have experience. Yes.
Thank you, Daktari. One of the issues lawyers have raised with regards to the Court of Appeal Rules 2022 is that there was no sufficient public participation. Could you kindly tell us what you did differently during your tenure at the Rules Committee that you may bring on board to the Court of Appeal when it comes to development of such rules?
Thank you, Commissioner. We consulted lawyers. We collected views. Even we made a draft. We circulated it in all the areas. We asked for comments. So the rules that we came up with were actually coming from mainly the lawyers themselves. There was intensive involvement of the stakeholders. That was the thing.
Okay. Thank you. And the second question is around decisional independence. Could you tell us more on what is your understanding of decisional independence?
Thank you, Commissioner. I understand that when you sit in a collegiate court, you are making one judgment. You are judging one case. But since you are 3 or 5 or 7, each judge has a duty to make his own decision, independently of the others. Even if you find yourself on the dissenting side, on the minority, but still be independent. And also at the level of the judiciary now as a whole, and the independence of the judiciary, judge, even if you are sitting alone, you have the constitutional right to make a decision independently of anything else. Decisional independence cannot be interfered with, even by the rest of the administration. That's my. I don't know if I've answered your question.
Not really.
Yes.
Maybe leave aside the collegial system. Just you as an individual, what is your understanding of decisional independence? Yes. What guides a judge in ensuring that all decisions made are independent?
The very first thing, the duty, the independence of the judiciary, first and foremost. The Constitution itself requires that you make the decision independently, even if it's the judiciary.
Independent from what?
Independent from all interferences, including independent from maybe your seniors, maybe from the president of the court. Yes, decisional independence. You can be controlled on all the other issues, administrative, all the rest. But when it comes to deciding the disputes, you decide it independently. That's my understanding.
Okay, do you think personal bias can affect decisional independence?
Yes. That's why there is a rule against bias. Yes.
You are just informed this commission that you are pro-life.
Yes.
When people who are pro-choice appear before you, how are you going to deal with that issue?
Impartially, with impartiality. The judge will stand above the scholar and above the personal views. Impartiality.
Okay, and I've also gone through your publications. I might say they're quite thought-provoking, and that's why I like academia in the legal sector. They make us think out of the box. Though I have a question around your paper on adjudicating land disputes in a rapidly changing social, economic, and political environment. One of the recommendations you're making under this paper is that the ELC, the Environment and Land Court, should exercise jurisdiction over criminal offenses involving environment and land. What is your view based on this conclusion vis-a-vis the role of other investigative agencies? And number two, the issue that you cannot be a judge, jury, and executioner.
Thank you. The idea is not that the ELC court exercises criminal jurisdiction. No. The idea is this, that if you sit at the case management conference and you determine that the only issue is whether the green card is forged, that is crime. That is a criminal issue. The idea is this, that it should be possible for the judge to refer or to call for a report from the Criminal Investigations Department on the criminality or otherwise of this document. Once that core issue is determined, the matter is finished. The issue of damages, the issue of who will be evicted is decided by the criminal investigations. So that is so there is no attempt to say that the ELC judge becomes an investigator or a prosecutor in a criminal case. It's just to decide the authenticity of that green card or title deed. Just that.
Okay. My last question is around indigenous jurisprudence.
Yes.
There's been concerns, especially within the academy, that courts in Kenya tend to over-rely on jurisprudence from other countries without custom-making it within our context. Is there any case that you're aware of where it has appreciated indigenous jurisprudence, and what would you do if you're appointed to the Court of Appeal to then propel this argument on need to enrich indigenous jurisprudence?
Very kindly, Commissioner, because they are very many questions in one.
Oh,
just
sorry.
please repeat it for me.
Yes, there are concerns,
Yes.
Especially from the academia,
Yes.
that as a country, most judges tend to rely on jurisprudence from other jurisdictions
Yes.
without understanding the context. So what we are seeing is that we are not enriching our indigenous jurisprudence.
Yes.
So what are you going to do if appointed to the Court of Appeal to enrich the jurisprudence within the country?
Thank you.
Indigenous jurisprudence.
Yes. I think it's very, very, very true that we rely too much on foreign jurisprudence, especially like on property rights. I saw a very good decision from the Supreme Court the other day, yes, indicating that if you are having customary rights, if this land was owned by the clan a long time ago, even if you are the registered owner, it doesn't defeat, the registration does not defeat the customary rights. So that is a decision that is recognizing our special circumstances. Now, if I were to become a judge, and I'm hoping that you'll make me one of the things I would suggest is that we engage in more research. I have tried in my own small way to analyze issues, yes, to analyze to do research, unpaid, and on my own volition. But I would suggest that we involve the JTI in more and more research, because to vacate that foreign jurisprudence, we need to have empirical basis of shifting from that position to the new position and being sure that it is sound jurisprudence and that it can work. So I would suggest more research. Yes.
Thank you, Honorable Chief Justice.
Thank you. The next set of questions, yes, by Commissioner Michelle.
Thank you, Madam Chair. Good morning, Professor.
Thank you, Commissioner, but I'm not a professor, let me correct.
Oh, not just a professor.
Dr. Andre.
Yes, I want us to focus a little bit away from law
Yes, thank you.
and focus now on your role as a public officer, as a state officer.
Yes.
I don't want you to focus on Article 232 of the Constitution. And I've seen from your CV here, in terms of financial matters, you are highly disciplined. I want you to focus on Article 232 1D. I will put it for you. Providing efficient, effective, and economic use of resources.
Yes, sir.
You might be heading a station.
Yes.
As a state officer.
Yes.
Could you share with this commission 2 things that you do to ensure that that article is fully realized during your term as a judge of the Court of Appeal?
Okay. Number 1, working with systems, the financial management systems. Yes. That is the very first one.
Would you share with us 2 legal instruments that will guide you? Do that one. 2 legal framework or instruments that will guide you.
Instruments like the statutes on public finance management. Yes, the statutes on public finance management.
If you could give us specifically 2 of them.
Yes. I'm starting with that one, the Public Finance Management Act.
Correct?
Yes.
Next one. That's 1. I need 2.
Yes. The other one would be public procurement.
Very, very important in terms of efficiency and productivity. 2 measures that you put in place to make sure that your staff working under you are productive, they're efficient, and they're effective. 2 strategies.
Performance management.
Yes.
That is one of them.
Measurement.
Yes, performance management, measurements, monitoring, and evaluating. That would be one.
Okay. I'm sure when you are preparing for this interview, you might have had a chance to look at the strategic plan of the Court of Appeal.
Yes.
And if you look at that strategic plan for Court of Appeal, they had identified 12 key stakeholders. 12. Would you share with us at least 3 of those key stakeholders for the Court of Appeal?
The advocates.
Advocate, good.
The litigants. The government itself, as in the states.
Okay. My interest is 2 of them.
Yes.
And 1 is the Attorney General.
Yes.
As a key stakeholders for the Court of Appeal.
Yes.
What are the expectations of the Office of the Attorney General to the Court of Appeal, and what does the Court of Appeal also expect from the Office of the Attorney General?
The Attorney General expects that the Court of Appeal will decide disputes expeditiously. That's number 1. And number 2, that the Court of Appeal will apply the resources allocated to it efficiently. Okay. Now, when you come to the other side, the Court of Appeal expects that the Attorney General will pick up issues that require perhaps making legislation and push them through parliament to become legislation.
That's one. Good. Next
Yes.
one.
Yes.
The last one from the Court of Appeal to the Attorney General. That's one.
Yes. Yes, the Court of Appeal would also expect that because the Attorney General is a party in so many cases, also he also prosecute his cases expeditiously. Yes.
Good. The other office I'm interested in is the office of the Director of Public Prosecution.
Yes.
What are the expectations of that office to the Court of Appeal and vice versa? Two of them.
So the expectations of
the office of the Director of Public Prosecution,
yes.
the Court of Appeal,
Yes.
and what does the Court of Appeal also expect from that office?
Thank you. I think the Court of Appeal, okay, I think that the DPP expects the Court of Appeal, number one, to do its duty of making decisions expeditiously. That is, yes, that's number one. Number two, to make decisions, to make decisions that are guided by a jurisprudence that takes care of our special circumstances in Kenya. And I'll give an example of maybe issues of maybe money laundering and terrorism. I think that is where the DPP has had